And so I wanted to introduce our panel now. We have three judges. You all know them, I'm sure. Judge Quigless was a trial judge in the city for a long time, till 2012, when she ascended to the Court of Appeals. I know I tried cases in front of her then. David Reuther is a newly appointed judge in the city of St. Louis. He had a private practice for many years in St. Louis County and Jefferson County in the city and all over, did a lot of good work. And Judge Vincent has been a trial judge in the city, and I've certainly been before him as well. We wanted to bring them in front of you, a little combination of city, county, Court of Appeals, newer judges, some more experienced, to try to talk a little bit about do's and don'ts of practice before them. So I'll let them kind of run through their things. I know Judge Vincent chaired a study on civility among lawyers that he wants to visit about. So thank you very much for doing this. And then if people have questions and stuff too as we go along, we're certainly feel free to raise your hands and make this as interactive as we would like. Thank you. Thank you. So Judge Quigless, what do you see? What do you see? What are the things that turn you off from a lawyer's argument? What are the things that distract you from hearing the message when lawyers are advocating their client's position?
The very first thing, and I think I can speak on behalf of my colleagues.
Move that microphone forward a little bit. I'm sorry. You have two microphones for all of you, so we can pass it along.
There we go.
I think I can speak on behalf of my colleagues when I say that the very first thing that we do is reread the statement of facts. And it's a complete turnoff when the statement of facts are not an unbiased statement of facts, which is what Rule 84 requires of you when you're filing an appellate brief. We get a brief and we will read the facts of the appellant, we will read the facts of the respondent, and if we seem like we have two different cases going on, you have already established not a very good credibility with your brief for our judges. Another thing that we do first, before we even delve into the merits of your argument, is reread your points relied on. And Rule 84 also tells you how you're supposed to draft your points relied on. It's the court erred because in that. And there's a purpose and a reason for that, because if you don't establish the error of the court and then tell us why it was error and how that error relates back, we are not going to advocate for you. We cannot advocate for you, and you've preserved nothing for appellate review. So that would be the first thing. Make sure you give an unbiased statement of the facts so that we can feel like we're getting a true picture of what went on in the trial below.
David, you want to go next? Because I'm just going to talk about the survey, or you want me to go right into the survey?
Why don't you go ahead and start with the survey and give the audience some background.
Okay. The one thing I do feel, I felt sorry for Judge Turner when she started to emailing me and Judge Reuther, you know, because she said, well, David, what do you think? And I said, well, I was talking to the other David, and I think she she skipped a book on Dr. Seuss, Too Many Daves, but I started answering the other Dave, or the other David. So I've been out in St. Louis County about 22 years, and right now it's like coming back and seeing a lot of faces I haven't seen in a long time, almost like a reunion. I want to thank you for your invite. Also, during the course of that 22 years, we started seminars on do's and don'ts for Missouri Bar, for St. Louis County. And what we did eventually, and I'm not going to go through the whole history because it would last at least an hour, is to say that we did a survey on this entire state judiciary in some out-state counties. Because one time I went to one of these seminars talking about do's and don'ts, and some outstate guy, I don't know, I didn't catch his bar number or his license plate, He wasn't offering it after he said, Judge, I don't care what you do in your courtroom because I will never appear in front of you, you know? And I said, oh, who, you know, I wasn't interested in finding out who it was because he was telling the honest truth. You know, what is done in my courtroom is going to be different from what is done in another colleague of mine courtroom. And so we did this survey, and if you're lucky enough, if you want to come up, there's about 19 of them left. I'll give you the 20th copy. Gary has the email and attachment of this exact survey of the entire state that we did back in, I think, 2001 and 2008. And the other one in 2016, because I promised some of the judges that I would do a 10-year anniversary when it started in 2006. I didn't promise another 10 years in 2026, because I don't want to do another one. So, oh, by the way, my background is engineering. No engineering jokes, please. And that's why I'm stuck with numbers on how to compute and what they like and what they do not like. Now, what this survey is going to tell you, give you the top 5 reasons on what judges like and what they do not like. And also to tell you about the 2006 and 2008 survey, and also the comments from circuits, from the first judicial circuit all the way down to the 41st or the 44th circuit. And in there, you're going to see a comment about something about mirth, and yeah, Tom Grady did respond too. So, you know, he's in there as well. Then you're also going to see what their comments are about why you shouldn't tort your adversary. Zealous representation does not mean that. There's a comment by a judge says some days you'll be the statute, some days you'll be the pigeon. Good luck. You know, be careful what you do. And it goes on into all of that. And also a third level that was added this last time on new or young attorneys. Because sometimes new attorneys may not be, well, you get the point. So in there, sandwiched in all of this, is also the oath of office to remind you of your initial oath that you've taken when you became an attorney, just so that it's a package into one to help you out. And it kind of gives you a sense of what the judges generally want in their division. Now, what does that translate? How does that translate for us, or for me in particular? Well, you got to find out either from your colleagues or you got to find out from the clerk of the court. She will tell you, you know, certain things that I do, certain mannerisms. If you have a bench trial and I'm asking you questions, like, don't you think you don't want to, if you don't want to be the other attorney interrupting me if I'm not asking you any questions. I've had an attorney during the course of trial, I was talking to the other attorney, and then he started chiming in, and then he said, oh, I'm supposed to shut up. And I said, well, where does that come from? Yeah, I'm on the bench. And he said, oh, yeah, never mind. And I said, I've never seen that. Of course, I ruled in his client's favor. And I said, I asked my clerk, where did he get that from? She said, I told him, if the judge is not talking to you, shut up. You know? So, you know, those are what kind of quirks we have, what kind of do's and don'ts. What you can do in my courtroom, I'm okay with. I treat my courtroom as the marketplace. If you come in sloppy and you give a jury a sloppy appearance, or a sloppy presentation, they're going to give you a sloppy verdict. You know, if you come in, you're well prepared and everything, a jury's going to give you a well prepared verdict. Or, you know, I get a sense that if you have a great presentation, I go, oh, this attorney knows what he or she is talking about. You know, that's what I appreciate. The one don't that I do have is don't mess with the clerk. One attorney came in, yelled at her for some unknown reason. Not a good idea. And I said, I'll be there tomorrow morning at 8 o'clock to let you know how I feel about your conversation with my clerk. He said, why 8 o'clock? I said, because I get here at 9 usually, and at 8 o'clock I'm very angry. And he came in at 8 apologizing, and I just said, what are you apologizing for? Well, I yelled at your clerk. I said, you're not going to do that again? No, I'm not. Of course, he didn't have to do that after he uses his changes of judges, but, you know, I didn't have to worry about that. But, you know, that's my only, you know, because we've been out there before. We practiced before. We know what you're going through. As long as you are somewhat prepared, as long as you present your cases, that's fine. What you don't want to do in my division is get on a radar. If you're on my radar, one person did something, crossed the line, he was on my radar. And as soon as his case was ready, he was one of those assistant prosecutors out there. He said, "Judge, I need a continuance." I said, "Oh, that'd be denied." "Well, can I give you a reason?" "No, you cannot. You're on my radar. You try to do something that was not in accordance with, I guess, civility. Now I'm going to show you what happens when that occurs. You're going to have to suffer the consequences of that. Either push your cases in another division or be ready, because what you've done in the past."
Judge Vince, of the list on your document, what rises to the level to you in your courtroom of what you don't like on the don'ts from that survey?
It's hard for me to say, because I know that attorneys struggle. If they're late, if they can call ahead, that'd be great. I do not expect them to be in more places than one. I do not expect them. I know that sometimes attorneys get real busy, but I do know that some attorneys slop off. We've had an attorney the other day. I said, "Well, why didn't you give him discovery?" He said, "Well, I just didn't get around to it, Judge." I said, "Oh, I see." I said, "So what do you want? Do you want a non-suit or do you want sanctions?" He said, "How so?" I said, "You're in front of me on a motion for sanctions, and you just didn't get around to it, so I might get around to this motion for sanctions, or if you take a non-suit, I don't have to do that." I said, "You want to talk to your client?" He said, "No, Judge, I'll take a non-suit." But, did I yell at him? No. I know the hustle and bustle of practice. I've had difficult clients in the past. I've seen opposing counsel. If I had an opposing counsel, they talked about they described him as a walking ethical violation. Him and I went to trial. We were fighting with each other, and there's a verdict. And, it's a little bit below my offer. And I said, I got the check. I'll get it to you tomorrow. He said, "Just put it in the mail." I said, "Pal, I do not trust you at all." We're going to have to go to the DMZ zone, and we're going to have to exchange this under high security before I even, and, that happened. I gave him the check. He gave me a satisfaction. And what did I saw him in the hallway the next week and say, "Hey, how you doing?" Because you have a job. You have a responsibility as an attorney. You have a lot of things that are going on. And as far as I can help with attorneys to say, "Okay, this is how we're going to do it in Division 9, we will try to get your case timely tried in a professional manner." Now, how fast can I go in Division 9? I tried a case 4 months after the petition was filed, and I didn't recommend it. No, my name doesn't rhyme with Beagle. Is Mark Siegel? Okay.
No, he's not.
He's not. Okay.
He's over at USAM
He's over at
across
USAM.
the street.
Okay.
Judge Roy, thank you. Judge Reuther, what about your experience on these do's and don'ts? What are you seeing in your courtroom?
Sure. So first off, I would ask all of the audience participants, when you get this study, go through it. There's actually 3 surveys, 06, 08, and 16. And what struck me was how little both lists actually change. And they're really the no-brainers that we'll talk about throughout this session. The two, one on the do list and one on the don't list, are kind of mirror images of one another. Be prepared, don't show up unprepared. Those are pretty much at the top of the list of all 3 years' surveys, and these are judges statewide. I will take it a little bit one step further. I have a family law background, and anybody in the room who practices in family law, you have an appreciation for exactly how much time we sit in line in chambers. Some mornings it can be hours on end. You show up for your 9 o'clock, you walk in at 11:30, and neither side is prepared to talk about anything. Don't waste my time. If we have nothing to discuss, just because I assigned you a settlement conference date, you know your files better than I. You know where you are at in discovery better than I. call me up the day before, tell me you're not coming in, pick a new date, come in when you are ready to talk business. But I don't need you clogging up my courtroom, billing your client now 2 hours to finally get in front of me to tell me we're really not prepared to do much of anything today. It just seems like a real inefficient approach for your offices, certainly an inefficient approach for my office. One thing I'd like to touch on that Judge Vincent touched on, popping up on judges' radar. Yeah. One of the things I'm learning is, and I am, let's see, almost a year and a half on the bench, still consider myself in a period of transition, just figuring out what my judicial philosophy is. One of the things I'm discovering as a judge that I didn't have an appreciation for as an attorney was, as an attorney, I was always looking for that one case on point, that one case that proved what the correct evidence ruling was. In my new world, I find that I live in a world of discretion. And every question, 90% of the questions that are in front of me, I can answer yes, I can answer no. I'm using my discretion, and either answer may be correct. I just have to stay in that lane of not abusing my discretion. So when you walk into my courtroom and tee off my clerk first thing in the morning and made her miserable, that is now going to make my day miserable. You've popped up on my radar. The next time you're in front of me, you may be asking me to utilize my discretion to assist your file. So while these rules or these surveys would seem a little not impactual for you other than polite courtesies towards the bench, they may in fact be impacting your cases. Because in the back of our mind, or in my mind, in a push, that may be one of the ways that I handle you being on my radar, is not using my discretion to help your file, and doing it in a manner that is, you can certainly appeal it, but I cannot be charged with abusing my discretion.
And I will add to that I don't know if there are many plaintiff's lawyers or defense lawyers or a mixture here, but what was surprising to me coming from the 22nd Judicial Circuit as a trial judge to appellate judge is that the standard of review at the appellate court is really a judge-friendly standard. And he's right. When he says abuse of discretion, it's really, really hard for you to get a case overturned because of, you want to say the court abused its discretion. And the reason for that is because most of the factual determinations and most of the credibility determinations are for the trial court, and we re-weigh those at the Court of Appeals. Discretion is given to the court on those areas. What we will look at anew with a fresh eye is questions of law and statutory interpretation, because our standard of review there is de novo, which means we don't have to give you any discretion at all. We look at it from the interpreting the statute, and we look at it from the law, and we can make our own determination given the facts from the court below. One thing that I will say is, for all of you trial lawyers, they tell you this in law school, but it really makes a heck of a lot more sense to you when you're at the Court of Appeals. When they say make a proper record, you really do have to make a good record below, because at the Court of Appeals, we don't find error on the trial court unless you've given them an opportunity to correct that error or to address that error below. So if you're going to object, although they tell you in law school, just say object if you don't know the reason, and maybe if there's a good reason, the trial court might throw you a bone. And that's true, but we can't throw you a bone at the Court of Appeals. So you can't just make a general objection and then in your brief and in your points relied on argue that and refine your objection by saying, well, you know, it was irrelevant because, or now it was improper in that, if all you said was objection. We're not going to find error if the court wasn't given the right objection. Your objections have to be specific. So please be mindful of that. I know a lot of people think, well, if I don't object, I can always ask for plain error review. That might work on a criminal case if we can find a manifest injustice there, but civilly, there really isn't a great deal of caution given by our court for plain error review, so don't expect that too frequently in a civil case. I will tell you that your points relied on, they have to be preserved and they should not be multifarious. That sort of drives us crazy. If you don't preserve your point on appeal, there is absolutely nothing for us to review at the Court of Appeals. If you say one thing on your Court of Appeals and you get in the argument section of your brief and you argue something totally different, if it's not in your point of appeal, we really don't have to address it. We'll treat it as abandoned. So your record is very, 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 very important when you get to the Court of Appeals.
Judge, you have a question?
Yes.
Hi, I work in the asbestos world. And one thing that a lot of lawyers do, particularly in the expert depositions, is all objections are in reserve and you can bring them up after the deposition in front of the court when it gets to the trial. So a lot of times defense lawyers will just sit on their hands and not do any objections because the plaintiff has already said they're all held in abeyance. You can bring them up anytime later on. I'm really uncomfortable with that and tend to object during the deposition, but that upsets primarily the plaintiff's lawyers. If you get a situation where the plaintiff lawyer has said, or any of the defense lawyer said, all objections are held in abeyance and you can raise them any time later on, just let me get through my direct testimony. Are you going to turn away any objection then that comes up later?
The Court of Appeals is not going to comb the record to determine what objections you made during a deposition that may or may not get admitted into evidence. Our court takes it very seriously as far as our standard of review of not advocating for either party. So, I mean, a lot of times what lawyers would do in depositions, they'll get up and they'll read from the deposition and they don't necessarily read the objection. So you haven't really preserved it for our review because you said it in a deposition, but you didn't bring it back up in court so that the court could properly rule on it. We're looking at court error. We don't look at you guys as error. So that's not going to work.
So Judge Vincent or Judge Reuter, when you're ruling on objections,
Right.
what tack do you take and to avoid sandbagging versus preserving the objection?
Only thing for my division, keep in mind, judges are different, and that's what we're trying to impress on you, that what I say may go in my division, but what another judge may or may not do, he or she may do something else. What I would look for in that deposition is the agreement or a statement of stipulation that objections may be preserved, and that has happened in my division. And if it's on the record or not on the record, I'm going to ask the attorneys anyway. Is that the agreement? Yes. Well, what's the objection to this statement? Well, what's the relevance, Your Honor? Lack of foundation. That to be sustained. So we can do that on a record or in the form of a motion limine or what have you. But you're running a risk. And you as an attorney, you have to take that risk on what judges do. Before I would go into that deposition, you talk to that clerk, talk to that judge in a pretrial. Judge, if we have a deposition and they want us to preserve our objections without making them, is that okay, or is that something that you want us to object anyway? And that judge may tell you, or that judge may not tell you. But I can tell you in the Division 9, I look at the record, and if there's a stipulation, I follow the stipulation. And if the stipulations and objections are preserved, yeah, they're preserved. Make them, sustain or overrule. But good luck in other divisions.